Good evening, welcome. As you all see, I have all of our panelists here. My name is Chandra Pitts. I'm the president and CEO of One Village Alliance and also the founder and co-creator of Raising Kings. This is a really powerful initiative that it's in its 9th year. You all, many of you, go ahead and just give a wave if you have been here for last year, the year before, and anyone who's been here since the very beginning. This event kicked off with the Delaware barristers being a part of it, with Wally Rushton and Herb Broadwater on Inauguration Day in 2012, when President Obama was inaugurated for the second time. It kicked off right inside of Ferris School for Boys. So we're really excited, and that day actually fell on Dr. Martin Luther King Day. That history is really relevant at this historic time in our nation again today. Again, I lead an organization, One Village Alliance, which is a 501c3 nonprofit with a mission to grow historically marginalized children and their families into true greatness through education, economic development, and the arts. That being said, we're a global social justice organization, and we put that at the forefront of every single thing that we do. Raising Kings is really created, developed, and implemented every single year with the purpose of changing society's prominent image, expectations, and the outcomes for men and boys of color, with a particular focus on African American and Hispanic Black men and boys. We take a very holistic approach to doing that, with engaging fathers, men, sons, coaches, team members, grandfathers, aunties, grandmothers, and particularly we focus on mothers raising sons, which makes up a big part of our community. And we do all this work with the assertion that it truly does take a whole village to raise a healthy child, a strong family, and a thriving community. With that, I want to welcome again some very special partners who have been with me in leading this work for the last 9 years. I want to take this moment to recognize Wally Rushton, who continues to curate this event on behalf of the Delaware barristers. Even though we don't see his face this evening, he is very present. And I'm really excited about these two phenomenal females that I'm about to introduce to you. If you could give a wave, Paige Chapman Esquire and Nicole Mosey. So we're really excited to have you women leading this project tonight, leading this event, and having a very important conversation. And I welcome your voices right now at this critical time in the nation where the voice of women, in particular Black women, are at the forefront. I welcome you both to the forefront of this event. And I welcome all of our participants and listeners to again share, text, and post to the 9th annual Raising Kings Conference and the Lewis L. Redding Street Law Session. Welcome to you, Paige and Nicole.
Thank you. I guess I'll go ahead and introduce myself first, and then I'll turn it over to Paige. So good evening, everyone. My name is Nicole Mosey. And before I dive into who I am, I just want to thank everyone for taking the time to be with us tonight. This is a program that I look forward to every year. I've enjoyed participating in it over the past couple of years. And so even doing it in this virtual format, I'm really excited about the discussion that we will have tonight, the topics we're going to dive into. So I'm looking forward to it all. A little bit about myself. I'm a Delaware native, and I currently am a civil rights attorney with the Delaware Department of Justice Division of Civil Rights and Public Trust. I also serve as the recording secretary for the Delaware Barristers Association, which is the affiliate group for African American attorneys here in Delaware. And aside from that, I'm just personally a constitutional law, civil rights law enthusiast. So again, I'm very, very excited about tonight's program.
Good evening, everyone. My name is Paige Chapman. I am an attorney for the Office of the Public Defender. I'm also the office's statewide diversity and inclusion coordinator. I currently work with juveniles again. I used to work in another court, but now I'm back working with juveniles on the criminal end. It's my passion. I love it very much. To follow up on Nicole's sentiments, I'm very happy for you all being here tonight. This is one of my favorite programs I like to be involved in and developing and participating in. I think it's critically important that everyone, and especially our youth, know and understand their rights. So I hope you guys enjoy this program.
And introductions from our other panelists. We will start with Mr. Fernandez. You're on mute, Mr. Fernandez.
Good evening, everyone. Thank you for having me. I'm very excited about being here. This is actually my first time participating in a program, and hopefully it will not be my last. I'm a former New Jersey State Trooper and I was specialized in EEO discrimination complaints for the state of New Jersey. I also participate in our Learn to Live program with our Kappa League program in the state of New Jersey, where we mentor young men, similar to what you guys are doing with the your program. Prior to my employment with the New Jersey State Police, I was a Philadelphia police officer. I'm a native Philadelphian, living in New Jersey, trying to slide over to Delaware. So once again, I am happy to be here, and hopefully I can contribute to your program.
Thank you. Officer Chapman.
Good evening, everyone. Thank you for the invitation to partake in this program. Very excited to be here. William Chapman. I currently employed by the Howard High School of Technology as a legal support services instructor. Prior to that, I served 27 years with the Delaware State Police as a patrol officer in criminal investigations. And I've also served as a constable with Wilmington University in the Brandywine School District. I'm excited to be here. Hopefully I can add to the information you guys are putting out.
Wonderful, thank you so much. And Judge Chapman?
You're still on mute, Judge.
Do that every time. My name is Bill Chapman. I'm the Chief Diversity Officer and Pro Bono Coordinator at Potter Anderson Caroon. Was served on 20 years as family court judge. And again, I think I said this last year, but one of the biggest things that make me proud today is to see Nicole and Paige. I had the pleasure of moving both of their admissions to the Delaware Bar. And so it just makes me proud to see them leading this program, and a good friend of Bill Chapman as well. Thank you.
Thank you so much, Judge Chapman. And our other participant tonight is Mr. Kiadi Harmon. Kiadi, do you want to introduce yourself?
Certainly, thank you, Nicole. Good evening, everyone. My name is Kiadi Harmon. I'm an attorney here in Wilmington, Delaware. I'm also a native Delawarean, went to UD, and while in law school, I clerked for the Chief Justice of the Delaware Supreme Court. And then after law school, I clerked for Judge Charles H. Tolliver IV of the Delaware Superior Court. I presently practice as a civil litigator here in Delaware, and actually throughout the Northeast region of the United States with a law firm based in New Jersey named McGivney, Kluger, Clark, and Intosha. I am here this evening because Wally asked me to be, and when Wally asks me for things, I do them. I think like many of us that are here. And I've been a part of, I was chairman of the Multicultural Judges and Lawyers section of the State Bar for 2 years. And I've been involved with the barristers for, I think, about as long as I've been licensed, which is going on 9 years now, I think. So I've been involved in this program before. It's fantastic. And I really appreciate the opportunity to be engaged tonight. Thank you very much.
Thank you. Thank you to all of our wonderful panelists. So I guess we're going to get started. So tonight we're going to discuss a topic that Paige and I feel is very, very relevant to what's going on. I'm sure, as we all know, this past year has been challenging for a variety of reasons. In addition to dealing with the global pandemic, our nation is also grappling with racism and living in a polarized country, not only politically, but with race relations and so forth. And so there's been a lot of activism, a lot of people interested in learning how they can become more civically engaged, and that's people of all backgrounds and all ages. So tonight we wanted to focus on students and how these issues may play out in their realities. And our goal is that by the end of tonight's program, everyone will have a better understanding of a student's First Amendment rights when it comes to school, as well as their rights with search and seizure in school. And then finally, how social media intersects with the First Amendment, freedom of speech, and also intersects with what's going on at schools. So I'm going to share my screen. Okay, can everyone see that all right? Great. All right, so since we're in a bit of a different format this year by doing this virtually, Paige and I thought that it would be most helpful if instead of doing a skit, we would do basically a story, a fact pattern. So I'm going to read, and we have some slides to accompany it, but I'm going to read to you a couple scenarios, and we'll take moments to pause and to digest what's going on. So without further ado, I will get started. Raheem is a 17-year-old senior at Newcastle County High School, a public school in Wilmington, Delaware. Raheem is very active in his school's community, including being president of the school's African American Student Union. Mrs. Johnson, who's an English teacher, is the faculty supervisor of the African American Student Union. We'll call them AASU. After the latest police shooting of Casey Goodson, the members of the AASU met at a local diner and decided to dress in all black and wear Black Lives Matter t-shirts to school on Friday. And they were going to do this as part of being a silent protest. The members of the student union posted announcements of this protest on their personal Facebook and Instagram pages. As president of the organization, Raheem also posted the protest announcement on the school-sponsored AASU Facebook page. So you see here, Raheem is on his Facebook. He's posting it personally to his page. On the far left, Floyd Taylor Blake, it is time to take a stand. On Friday, join the AASU and wear a Black Lives Matter shirt in solidarity of police reform. He's also posting to his personal Instagram account, Black Lives Matter Silent Protest. Be sure to wear a Black Lives Matter t-shirt to school on Friday in honor of the Black lives we lost. And then to the far right, Raheem is posting similar messages on the Facebook page of AASU. And it says, AASU refuses to be silent any longer. Join us on Friday and wear a Black Lives Matter shirt in silent protest of police brutality, armed and ready to go if things get out of hand tomorrow. So at the start of this school year, the Newcastle County High School adopted a new dress code policy prohibiting students from wearing political paraphernalia. So as Raheem and his friends are planning this, Kelly, who is another student at Newcastle County High School, sees the social media posts by Raheem and by his friends, by other members of the AASU. And she sees these posts the night before the silent protest. So while reading the comments, Kelly reads the post from the AASU Facebook page that says, Raheem will be, quote, armed and ready to go if things get out of hand tomorrow. Kelly was immediately frightened and told her parents, and Kelly's mother called the school's administration promptly the next morning. So the next morning comes, Raheem is at school with his classmates. They're happy, they're excited that they're doing this silent protest with their shirts, they're taking pictures. And then while sitting in homeroom, Raheem was approached by his homeroom teacher and the assistant vice principal. The assistant vice principal, Mr. Jackson, advised Raheem that they have reason to believe he has weapons and contraband in his locker and would like to search him and his belongings. So Raheem was then escorted out into the hallways and led to his locker. The vice principal, Mr. Jackson, and the homeroom teacher unlocked Raheem's locker and began searching his personal belongings. No contraband was found. Raheem was then led to the principal's office. And before sitting down, Mr. Jackson conducted a pat-down search of Raheem while he was in the presence of the principal and the homeroom teacher. And again, nothing was discovered on Raheem. No contraband, nothing illegal. So we're going to take a moment and pause at this point in our scenario. I invite our panelists to share initial thoughts, reactions to what's going on so far in this story with Raheem, with his friends, and with the school, and also our attendees. If you have any questions or any initial thoughts on what's going on, please feel free to type that into the chat box or the question and answer box.
So I'll get started. So for our lovely panelists that are left, I don't know if out of the three of you, if you guys just want to unpack this first part, or I have some softball questions that I can throw at you guys if you just want to do a question and answer.
Toss that softball.
Gotcha. So my first question for you is, for the three of you rather, did the vice principal need Raheem's consent before searching his locker? What are your thoughts? And since you're not muted, I will start with you, Dad.
Okay. No, the vice principal was acting in a reasonable sense for the good of the school. He has a responsibility. And two, at the beginning of the school year, the school and school district sends over several packets of documents that parents sign. Within those documents are the rules and policies and regulations, not only for the school, but for the district, of which explains under the Fourth Amendment in that particular case does not uphold in a school setting. Essentially, the student doesn't have a Fourth Amendment or right to privacy in that particular situation.
I see, Mr. Fernandez, you also wanted to add into that?
Yes, as a former school resource officer, you have the responsibility of providing protection for all the students and faculty while still trying to maintain a welcoming environment. So in the case that Raheem posted on the student or the school social media page that he would be quote unquote armed and ready, I think that rose to the level of caution where they would have to actually investigate that to make sure they would protect not only the other students and faculty, but also Raheem from doing any bodily damage to anyone.
Paige, I would just throw back to you that would you since there's nothing found, you know, there's really no issue, right? Since there's no contraband. So I don't think there'd be grounds to challenge the search or the pat down.
I agree. So next question. and I don't know who wants to take this first. Do school officials need reasonable suspicion to search a student's locker and or personal belongings? Or I'll add, do they need probable cause? Mr. Fernandez?
I'll take a stab at it, put a little pressure on me. You guys are the attorneys, but being that we're talking about school property here, I think reasonable suspicion would justify any actions for a search.
Anyone else want to add?
Yeah, it's not, I know it's not, the standard is less, it's less. I have to go back and read the cases. I know that the New Jersey versus TLO case, that's years and years and years ago, but it's a lower standard than reasonable suspicion. But I don't know the exact language. I'm sure you two probably know.
I would agree with Judge Chapman. The standard is reasonable. The school officials are acting in good faith, number one, and the posting and the fact that the victim/student was concerned enough to bring it to the school, and the school was concerned enough to bring it to either at least met that reasonable standard, thus a pat down. Number one is reasonable, and two, the search of the locker would not require probable cause, nor reasonable suspicion.
Thanks. So
Above a hunch, below reasonable suspicion.
thanks. Judge Chapman actually kind of took my thunder. So there is a famous case. If you're an attorney, I don't know how famous it is to regular society, but is the New Jersey versus TLO case. And so the standard for search in school, according to this case, which sets the standard, is that a search of a student by a teacher or other school official will be justified at its inception when there are reasonable grounds for suspecting that the search will turn up evidence that the student has violated or is in violating of either the law or the rules of the school. Such a search will be permissible in its scope when the measures adopted are reasonably related to the objective of the search and not excessively intrusive in light of the age and sex of the student and the nature of the infraction. So all three of you guys were correct. It's no probable cause. It is based on reasonableness, and the court does make reference to reasonable suspicion. So it is akin to a reasonable suspicion if you were out in the street. Like Officer Chapman stated, because the victim was concerned for her safety, she notified her parents, who in turn notified the school of a threat. And there was a search of his locker and just a pat down of his outer clothing. The school officials were reasonable in their search. They had reasonable grounds to believe that a crime or at least a school violation was committed. So that's good. And it looks like we have a question in the chat. So is there a different standard for private schools? Yes, I meant to mention this earlier. So in the context that we're talking, it's really important to note that this is a public school. So teachers, principals, school staff that work in a private school, they are considered state actors for the purposes of the Constitution and the 4th and 14th Amendment. Private schools, if you're a fully independent private school, you are not, the Constitution does not apply to them, so the standard is different. Not sure if anyone else wants to add to that. Okay.
I'll just add a little bit. As a parent, one of the things that we looked at when we were deciding where to send our kids, not only was the curriculum, but also the culture, so we would know or feel a little bit more secure and comfortable when we dropped our kids off to school, that there was a culture in place that would limit, not erase, because anything can happen anywhere, but just limit or reduce those incidents of violent or disruptive behavior. So we actually decided to enroll our kids into a Catholic Catholic school system at the time.
Thank you for sharing. So next question. Do school officials need consent or permission from a student's parent before conducting a search of the student or their belongings?
I'm sorry, could you just repeat that? I just want to make sure I understood that correctly.
Yep. Do school officials need consent or permission from a student's parent before conducting a search of the student and their belongings?
You might not be able to get the parents, but you better have another custodian there, because it might not always be feasible to contact the parent in a situation like we're talking about, but you better have another, custodial person there with you to supervise.
I would tend to say no. Am I good?
Yeah.
My experience would be no. And of course, every situation brings about its own set of circumstances. That's the fact pattern that was described here. Though it was not an emergency, it was enough of a concern to warrant the search, and to delay by waiting to contact a parent could put the school and the administrators into a situation where their safety and the school safety may be at peril. So, and another thing I wanted to add to that, just for our audience's knowledge, we hear a lot about officer safety. The very first search is going to occur. It's really not a search, it's going to be a pat down. As soon as Raheem was taken from that classroom, he probably will be escorted to a private place for him to be pat down to make sure there was not a weapon on him. Just a sequence of events. I didn't want anyone to be shocked. And then he would be escorted to his locker where that search would occur, contacted prior to the search or the pat down occurring.
So as a follow-up to what you just stated, Officer Chapman, and this is for anyone, does it make a difference whether it is a school official or a school resource officer that conducts the search of Raheem?
That's a good question. And I'll answer it in a couple ways. There's been research of hiring constables who not have arrest.
Officer Chapman, I think we're having a bit of technical difficulty. I don't know if you can hear me, but you are breaking up.
I'm back. I just went to stratosphere somewhere.
Okay, are you good now?
Okay. So yes, no, to answer the question, no. The search of the locker can be conducted by the school officials. It's not necessary that the police officer conduct the search. That officer is going to be present to document the search, document what was recovered from the search, if anything was recovered, because that information will be needed for the sworn officer to be the affiant on a warrant if there's any arrest actions going to be taking place.
Paige, just to add to that, I sit on the Juvenile Justice Advisory Group here in the state of Delaware, and there's a lot of states, I know Maryland in particular, that are looking to ask, what's the value of having a school resource officer in the school, and whether or not it's appropriate, and whether or not there leads to more arrests in schools that necessarily that are not necessary. So some states are really looking at the function of the school resource officer and whether or not they ought to be removed from the school. But I don't think it makes a difference if it's because I think, like you said earlier, the school official is acting as a state actor. So I don't think it makes much of a difference whether or not it's the state school official or the officer doing the search.
And I think the case law agrees with you, Judge Chapman and Officer Chapman. Mr. Fernandez, did you have anything else that you wanted to add to that topic?
No, I think it was thoroughly covered.
All right. I'm not sure if there's any questions or thoughts to the audience, so I'll pause for a moment for that. Right. Nicole, did you have anything that you want to add?
So can you all hear me okay? Can you all hear me okay?
Yes.
All right, and I'll invite Gotti back in to share his screen as well. Because we do have several questions. So we have robust conversation happening from in the audience. We're on Facebook Live, we're on Instagram Live, and we have several questions. So one was the parent contacted. I just want to go back to exactly where these questions were. So in this scenario, had the parent been contacted was the very first question.
So in this scenario, yes, the parent had been contacted, but not for the purposes of getting permission to conduct a search, just to come in to have a parent meeting conference.
Okay. And that was Renee Mercer. Matthew Johnson has mentioned that, you know, most schools get a packet and parents have to sign it kind of to agree to something that, you know, the policies or procedure that's in place. So are parent packets provided at the beginning of school to kind of, considering the climate of the nation, prepare student body and, you know, families for these situations?
I'll leave that to Officer Chapman, who works in the school.
Well, the student packets go back decades. So even though we're dealing in a climate that may suggest that that's part of it, so yes and no. The school rules and district regulations do come in that packet. They expect the student and the parent to read those packets together. Even now, they'll come electronically where the parent has to sign on that they have read this and gone over this with the student. For that very reason, should something come up in the future, you should know what the school rules and regulations are. And that's everything from dress policies, anything that may result in any type of disciplines coming from the school. You will know that in advance.
Okay. And we also have another attorney, Courtney Swanson Davis, who I think you already answered this question. Private and public schools, are their policies different?
So, I mean, I'm sure individual school policy is different. However, the Constitution will only apply to public schools because they are considered state actors. It would not apply to private schools. So your Fourth Amendment and 14th Amendment protections are not the same in a private school setting.
Wow. Even though the private school is in the same country where the citizens are protected and guided under the Constitution. That's very interesting. Thank you for that.
I do have a question from the audience. Would you like for me to read it?
Yes, please.
This is from Christine Keels. It reads, in light of the racial unrest in our country, should schools provide seminars, programming, and support groups to help students deal with cultural, societal, and environmental stimuli? Advanced planning is better than reacting.
I would agree with that. I don't know who wants to take that question, but I mean, I think that they should.
I think there has to be a partnership between the schools and, the community, parents. So everyone has to be on one accord and has to reinforce, the objectives that we're trying to instill in our kids. So, we always say parents have to parent. So, school systems and education systems have a lot of burden on them these days. So we want to make sure that as parents, as the community, that we support and encourage and work with the schools to try to send the same message and not rely on the schools to do all the work. Because it's like I said, the school systems are dealing with a lot as far as trying to educate our kids, dealing with all the social issues. So the school system have to have the support from the community.
I have one more question, and I'm happy to see so many of our teenagers watching. Thank you, families, for tuning in with your students, because I think this is important. One of our Teen Freedom Fellows wants to know about the peaceful protest. So are students permitted to peacefully protest without the threat of violence during the school day on school property, or do they need school permission to do that?
So can we save this question, because I believe Nicole is gonna address this in the second half.
Wonderful.
All right, are we ready to move on? Okay. So to bring us all back to the story, Raheem has just been patted down and locker search. He's in the principal's office at this point. So shortly after the search, Raheem's mother and Mrs. Johnson, the African-American Student Union supervisor, walk into the principal's office. Principal Fitzpatrick advises everyone that Raheem will be suspended for 3 days for wearing prohibited political speech, which violates the school's dress code. Raheem and his mother appeal the suspension to the superintendent. In the meeting with the superintendent, Raheem and his mother argue that amidst the events and conversations occurring within the United States around race, police brutality, and the like, Raheem and his peers were exercising their First Amendment rights to free speech and freedom of expression. Raheem and the student union members used their personal social media accounts outside of school to spread awareness of their cause. The school does not monitor or control the social media platforms. They are public facing and are protected by the First Amendment. Even Raheem's posts on the student union's Facebook page should be protected for the same reasons. Their decision to wear Black Lives Matter shirts was a non-disruptive act of solidarity with the world events that directly affect them. Wearing the BLM shirts does not interfere with students' learning or school activities. It is merely young people expressing their constitutional rights. So that was the argument that Raheem and his mother made. The principal argued that the actions of Raheem and the student union members were inappropriate and are not protected by the First Amendment. The school has a strong and legitimate interest in maintaining an environment that is safe for all students, faculty, and staff, as well as ensure that the education is the #1 priority without any distractions. Students cannot express their opinion at any time, especially when it interferes with students' ability to learn and teachers' duties to educate. Raheem and the students wearing BLM shirts was the distraction by drawing attention around the school. The students were also in violation of the school's dress code. Additionally, the principal also argued that Raheem's social media posts, especially the student union's Facebook page, ran afoul or against that of the first, or violated the First Amendment. Their social media posts caused other students to be concerned and worried for their safety. The posts discussed an activity planned to occur on school grounds without the permission of any faculty member. The student union's Facebook is sponsored by the school and is subject to editorial review by the school because of the school's interest in circulating information that is consistent with its values of civil social order and academic excellence. The student union Facebook page is representative of the school and is subject to its control. So, Nicole and our panelists, what should the superintendent do?
So I'll let, if our panelists have any initial thoughts on this, what do you think? I mean, is Raheem, let me start off by asking this. The conduct that Raheem did, just wearing the Black Lives Matter shirt, and for him and his classmates meeting and saying, this is what we're going to do at school on Friday, is that conduct, does it matter that that conduct happened outside of school or not?
Nicole, I think what I would do is, I don't know the case law, what the case law, I'm obviously not a First Amendment lawyer or constitutional scholar, but, if I was a principal or the superintendent, I'd be more concerned with the armed and dangerous quote, or, armed if something's going to go up. I'd be more concerned about that than the post, the other post, or the clothing. That would be my, but then again, the other part is it's a teachable moment, and suspension, I'm not sure is the right result, but don't know the case law.
I tend to agree with the judge. I'm clearly not a constitutional scholar, and I would definitely concede that to the two attorneys in the room. However, my concern would only be if the way the criminal code reads in the state of Delaware about a terroristic threat, which would be more related to the nuanced threat of I'm gonna be armed and prepared to go. As far as the clothing, the way the code reads, if you cause a serious inconvenience. Now, if the superintendent is acting on the possibility that the protests would cause classes to have to be dismissed or cause disruption to the school day, maybe his actions would be backed up with that, but it doesn't appear there was any inconvenience to the school day or disruption. And again, I would agree with the judge. I don't know that it reaches the level of a suspension, certainly not an arrest or any discipline on that level.
I think
Mr. Fernandez, okay.
I think that the two issues that stood out to me were, of course, the post that, would have gotten me on alert, which some action would have had to been taken just to make sure that there was no threat. And also the violation of the code, not so much what they were wearing, but they violated the dress code. And you just want to make sure that you're reinforcing your code of conduct and your rules. So acts of, say, disobedience or whatever they may be aren't perpetuated through the wrong response of the violation. There definitely needs to be a discussion to allow the students some kind of forum to express themselves. But I think it would have been better suited if there would have been some kind of communication or outlet for the students to talk to the faculty, so they would have had that platform. But like I said, we always go back to, just providing a safe place and a healthy environment for our students and our faculty. So when those things come into question, then we have to make sure that they're addressed. But moving forward, you always want to come out of these situations being better with a resolution than actually just coming down and eliminating the threat with a possible resurgence or reaction the next day.
Thank you. I mean, each of you guys, even though civil rights, constitutional law may not be your strong suit, all of the responses are very much on point. And I'm really impressed. So to dive into what's going on here and kind of how this is related to what our Supreme Court has said on these issues, first let's focus on just the act that Raheem and his classmates decided to do as far as wearing these shirts to school. So let me see. Okay. So the first case that I want to focus on is Tinker versus Des Moines Independent Community School District. It's a case from 1969. And a little bit about what happened in that case. There were a group of students who were opposed to the Vietnam War. And so they decided that they wanted to show their opposition at school by wearing Black armbands with the peace sign on them. And so they talked about this at the Tinker's household, which is their picture there, Mary Beth Tinker and Jonathan Tinker, their brother and sister. They came up with the plan to wear the armbands to school. The school got wind of what they were planning to do and decided to create a policy that then banned armbands being worn at school. So by the time the students came to school with their armbands, they were violating a school dress code policy. And so they refused to remove their armbands when the school officials told them that they were in violation of the policy, and they then were suspended from school for not removing their armbands. And so what ended up happening, the Tinker family, on behalf of them and the other students that were suspended, they filed a lawsuit and went all the way up to the United States Supreme Court. And it was basically the question of, was the school dress code policy violating the students' First Amendment right to free speech? And the United States Supreme Court decided, yes, it actually was a violation. The court decided that students do not lose their First Amendment rights when they step into the school territory. And again, we're focusing on public schools because public schools are considered to be part of the government, and so they are state actors and they have a responsibility to uphold and honor our constitutional rights and individual liberties. So the court said that students' rights just don't go out the window once they go to school. And that moreover, this form of speech, by wearing a piece of clothing, an armband, is considered to be symbolic speech. So it was the first time that the court was recognizing that freedom of speech does not solely mean what you say verbally or what you write. It's about what you do. It's about conduct as well. So marching and protesting and making signs, wearing t-shirts, all of that would be considered protected symbolic speech under the First Amendment. The court did say, though, that there is an exception, that this First Amendment right for students is not entirely absolute. And that exception is if the conduct or the speech materially interferes or substantially interferes with the school's goal of being a learning environment, then in that case, the First Amendment right may be revoked or minimized by the school. So here with Raheem, the conduct of him and his friends deciding to wear the Black Lives Matter t-shirts, and then coming to school and just showing up and going to class as usual would more than likely be considered protected speech, protected symbolic speech under the First Amendment. And the dress code policy that Newcastle County High School had would then be invalid. It would be violating that right because their code is too broad, honestly, especially banning political speech, which is one of the most protected speeches there is. It's important to note, though, that with the Tinker case, the case not only recognized students' First Amendment rights, it also recognized the First Amendment rights of staff and teachers. So that right extended to teachers to also vocalize their First Amendment symbolic speech or free speech while at school, so long as it doesn't interfere with the school environment. So I know, like right now, we may see teachers wearing Black Lives Matter t-shirts or Blue Lives Matter t-shirts or flags, and all of that would be protected at a public school. Any thoughts, feedback on that before I hop into the other case? Okay. So the second case that's really important here with Raheem is a case called Hazelwood School District versus Kohlmeyer. And so in that case, again, this is about almost 20 years after the Tinker case happened. There's a high school journalism class that is responsible for printing the high school newspaper every other week. And so the upcoming newspaper contained 2 articles that were, one about teenage pregnancy and 2 about the impact of divorce on a teenager. So every time the papers were printed, the proofs would go to the principal would take a look at them, approve them, and then they would be printed and shared amongst the school. In this particular instance, the principal saw the articles about teen pregnancy and the divorce article and decided that those were 2 articles that were inappropriate, that were too taboo. And so the principal deleted those articles from the newspaper without telling the students, and then allowed the paper to be printed. And so when the students saw the printed paper without those articles, they were upset. They felt like their First Amendment rights had been violated. And so again, they sued the school. So the case goes all the way up to the Supreme Court once again. And the whole question is whether the principal, by deleting those articles, especially without telling their students, violated their First Amendment right. And the Supreme Court said, no, it did not. And the reasoning behind that was this was a school-sponsored paper. The school paid for the paper. The paper was a product of a school class. It was an assignment they had to do. And so in that case, the school has an interest in making sure that anything that comes under its name, where it looks like it's sponsoring, it's involved in some way, they have an interest in making sure that that message is consistent with who they are, what they value as a school, and maintaining civil order. And so the principal was within his realm to do that. When you take that and turn it to Raheem's story, Raheem, he posted on his personal social media posts. He also posted from the school-sponsored page. And from that school-sponsored page of the AASU, Raheem can actually be regulated from what he could say. So not only was the school put on alert because of the threat that was posed in the speech that he put on the school-sponsored page, but the school was also put on alert because they may not want to take an official stance on the police brutality and Black Lives Matter issue. So that would be a point where the principal in Raheem's case, if he wanted to penalize or remove that post from the AASU page, he would be right or correct in doing so. So any thoughts, questions about those 2 things, those 2 cases?
So Nicole, this is Chandra again, and we have, again, several people tuning in. Welcome to you all. I have a question from a local teacher. She said this is just a confusing issue. How does a teacher navigate through so many discrepancies in, with the Constitution and just kind of understanding from a teacher's perspective?
That's a really great question. This is complex stuff. It's not stuff that, a lot of people know off the top of their heads. And so I'm not sure if there's really a best way or right way to navigate it. It's all a matter of, I think, having conversations and asking questions before actions are taken. So from a teacher's perspective, if there is a student or student group that seems to be mobilizing in some way, where they are expressing themselves with wearing a t-shirt or having a sign or some type of gathering, it's a matter of having a conversation with administration to see first you know, where does this stand? Because free speech, it's great. It's really broad, but there also are some gray areas. There's a fine line between, you know, saying we protest the Vietnam War, Black Lives Matter, versus hate speech that maybe targets particular groups, that intends to demean or intimidate in any way. So before action is taken, I feel like the best way is to kind of have a conversation and see like what's going on here, how is it impacting the school environment or other students, and kind of going from there.
Yes, and that same educator reports that she's seen students being suspended in some schools. There's another educator who's chiming in that says at their school, they're not allowed to wear any political shirts at all. So again, the ambiguity around what is a political shirt. So the great thing, I think that's why this conversation is so important, because we can be more informed, at least about your rights. Now, when you know that these things are based in the Constitution, and you know, you just have more information, and hopefully people feel more empowered hearing from attorneys and judges and law enforcement officers, at least to chime in from your different very knowledgeable perspectives. So thank you all.
And to quickly add to that, 2 points. Just like Paige mentioned earlier, how there is a distinction between public and private school when it comes to the Fourth Amendment, search and seizure, and the 14th Amendment. The same is also true for the First Amendment. So students at public schools, they are entitled to these constitutional protections. The staff is entitled to these constitutional protections. But students and staff at private schools do not have these same constitutional protections. In fact, they don't have any. The private school has way more authority and control over the speech, the conduct that is shared or disseminated amongst that school. And my second point, something that I found really interesting about Delaware. So these cases basically set the bare minimum of what what schools have to recognize and do. But states can set a higher standard or give more liberties and protections. So when you look at Delaware is pretty much aligned with these Supreme Court cases. They don't give much more than that. But one thing that I found very, very interesting was that when you look at the Delaware Code, you look at Title 14, which focuses on education, the provision that focuses on the First Amendment in schools says that at every public school in Delaware throughout the state, on the first day of school, during the first period of that day, the teacher in that class has to either read or recite the First Amendment to the class, to the students. And that really surprised me because I'm a product of public school in Delaware, and I could not think of an instance where my teacher on the first day of school in the first period took a moment to enlighten me about the First Amendment and my rights. So that kind of raised the question of how that is being enforced within the state, but that is something that is actually a legal mandate in Delaware.
Wow, that's very interesting.
So I guess if no other questions for me, we'll just open up the floor for general questions from the attendees, thoughts.
Nicole, this is Kiati. I had one. Taking it back just a little step earlier in this process, is it a given? Are we accepting that Black Lives Matter is a political statement such that it would violate the dress code on its face? Or another way to ask that is, does Raheem have an argument that Black Lives Matter isn't a political statement, it's a statement of fact?
That's a really, really great question. And I think he would. Black Lives Matter has been tied to politics It sometimes seems to be a buzzword for some of our politicians, but it's a movement that I think touches into social realms, into cultural realms. And like you said, as just a matter of fact, it's a humanitarian human rights issue. So I think there would be an argument for Raheem to say that on its face, it wouldn't violate it because it's not considered a political statement or a political t-shirt. But there's some gray areas there.
I'll add to that. I looked at the Morse versus Frederick case, which is a little bit more recent. It's a 2007 case, and I don't know if you want to talk about it, but in that case, they talk about the substantial disruption standard and how the substantial disruption rule of Tinker was not the only basis for restricting student speech, and that the administration can consider different factors than the substantial disrupting rule, and are entitled to take steps to safeguard those entrusted for their care. And this was an illegal drug use. It was the promotion of illegal drug use, where they said that other factors could be added to the substantial disruption rule. I just wanted to bring it up because it was a little bit more recent.
Yeah, thank you for doing that. And you are right that the Tinker kind of set that foundational understanding of that standard of substantial material interference or disruption. But there have been other cases since then, since 1969, that expands upon that, Frederick versus Morse being one of them. I know that that has to do with dealing with drugs in school. I know there's another case, any speech of long hits for Jesus, is something that can be regulated by the school. So there are some other cases that discusses free speech and schools and public schools. But for today, I just want to give a pretty foundational understanding for everyone.
Thank you very much, Nicole. We wanted to bring Kiati back on the screen. And Nicole, if you could stop the screen sharing now, just so we could kind of just have some final thoughts from all of the panelists. Thank you. We'll welcome Kiati, and thank you for really helping to manage questions from the audience. We've had such a robust conversation online with many questions. A lot of information was disseminated. So, we are in a very, very interesting time in this nation, and a lot is being put on our youth. Even if you think about different eras and how young people and youth, and, I think back to a time before my time, the Children's March, right, of the 60s. So youth have always been involved in leading movements and protest and standing up for what's just and right. Any thoughts just overall that you'd like to give to parents, educators, or in particularly our youth and students who are tuned in this evening?
Before that, I think there's another question, and Nicole, I'll direct the question to you. It's from Christine. Would Raheem's intent for the use of Black Lives Matter be considered in a case? Was his intent to remind of the humanity or to motivate protest or other such actions to go beyond sensitivity?
Thanks for catching that, Paige. So in our fact pattern, this particular scenario, Raheem's intention was to wear the shirts as a symbol of humanity, that Black Lives Matter. And his intent would be considered, but I'm not sure if it would have that much bearing on the case. When we were talking about First Amendment cases, a lot of the time they're just looking at what the conduct or the speech actually is, how that affected other people, and the repercussions of it. They may look at intent, but it may not have too much of a bearing. Well, to answer Ms. Pitts with the question you posed, I mean, I've always been a very civically engaged and outspoken person, going back to being in school, middle school, high school. So I always tend to encourage people to be active and speak out. There is a time and place for everything, and there are certain ways that you should consider how you're translating your message. But foundationally speaking, I encourage students to express yourselves appropriately and respectfully in your environment, especially if you're in a public school.
While I have a captive audience, I just want to put my defense attorney hat back on to say to everyone, even though this really doesn't touch on the story that we gave today, I just want everyone to please remember, do not consent to searches. If the police ask if they can search you, do not waive your Fifth Amendment right, and talk to officers when they want to interrogate you or question.
Well, what should they do? What do we say?
Call me.
I want my lawyer. That's right.
Call me. Call the public defender's office. Parents,
Right.
if your kids have been detained by officers and the officer is asking for your consent to talk to your child, the answer is no, they don't have your consent. You want your attorney. So that's what I like to preach all the time. And also all the lovely things that Nicole said about being active and engaged in the community as well.
Paige, I don't mean to put you on the spot, but do you think maybe it'd be useful to explain what the Fourth and Fifth Amendment are? Actually, I think we've mentioned them, but I don't think we've actually explained what they say, what and what rights we derive from them, frankly.
Sure, and Judge Chapman, Officer Chapman, Mr. Fernandez, please jump in at any time if you want to add to it. But the Fourth Amendment is your right to be free from unreasonable search and seizure from the government. And as we talked about today, that includes school officials as well. So in order to be searched by the police or have your belongings searched, the basis is that there needs to be probable cause. Probable cause is kind of a high standard, kind of not. It's more than a hunch, it's more than reasonable suspicion, but they need to have particularized facts to say the reason for the search. That's usually done in a warrant, a written warrant that's approved by a judge, or if there's probable cause, they can do the search there. That's the basis. However, there are a lot of exceptions to the Fourth Amendment. So as was kind of touched on earlier, for officer safety, they can do a pat-down search review to ensure that there's no weapons on you when they're about to conduct an arrest. If there's an emergency situation because there's a foot chase, and they see you go into something or doing certain things, they can stop and search there. There are exceptions, we don't have to get into it. Reasonable suspicion is brought up a lot as well. We can have a whole class just on that. But the Fifth Amendment is the right to self-incriminate or to not self-incriminate. That only applies once you are detained by an officer and you are being interrogated or being asked questions, incriminating questions. Officers do not need to tell you when you're being arrested. They don't need to read you your Miranda rights like you see on TV. That's not when it applies, just because you're in custody or being held. But once you are being held and being questioned, they must advise you of your rights. You have the right to remain silent. You have the right to ask for an attorney. It's important to note that even if you are invoking your right to remain silent, that doesn't mean that the officers have to stop asking you questions. They take a break, but they can always come back to you once you expressly state that you are requesting an attorney, you want to speak to your attorney, they cannot talk to you without an attorney. So they can't come back 2 days later and try to talk to you again. And then after that, your Sixth Amendment right falls in as well, which is also having a right to counsel. I don't know, Judge Chapman, you want to add more to that? I kind of went fast, but.
Excellent job with no notes. Excellent job.
Thank you.
Only thing I would add to, it's hard to tell, Ms. Pitts, how many young folks are involved, but to any young folk that are involved or watching on a Thursday night at this time, I think that shows that you're interested in the law or career in law enforcement. And please get our email address and phone number. One of the things that I think is really important is that we were on a bar committee meeting this morning and really trying to make sure there's a pipeline, a diverse pipeline. Paige and I both work in this diversity space. Brother Harmon did a lot of work on the diversity. And so the more folks that we get looking like us in the representation in law enforcement and the legal community. And if you don't know somebody that's done a job like this, then it's hard to get a sense of whether that's something that you want to do. So please, I think all of us would be honored to talk with you. So Ms. Pitts, if you can just, I don't know if we put it on, I don't know how to put that in the chat, my email and phone number, but please do that so that, and young folk, please call us, please.
Thank you so much for that important invitation, Judge Chapman. That is, yes.
Ms. Pitts, if I may, since the attorney in the virtual world has made her statement in reference to how to protect yourself from the police, while we have a captive audience, I would also like to invite parents to engage the police. Everything is not a negative interaction or encounter. One of the pet peeves I have always had is when I'm in the mall and a parent will point out a uniformed police officer and tell the child that that man is going to get you if you don't behave. No, I think we should be doing just the opposite. When we have that young, impressionable mind, make that officer prove that he is or she is the person that we expect him to be. Engage that officer, especially in times when you're not facing handcuffs and pat-down searches. Let's start on our end to build that relationship and not wait until we're 24 years old and can't wait to get a police officer in the courtroom to break him down. Let's have that relationship before that.
Thank you so much for that, Officer Chapman. We really appreciate your service and your comments, because youth need to hear more from officers like you, and so the families and the whole community, actually. So thank you. Any final thoughts, comments?
I'll just throw in one more plug. So Nicole and I are also co-chairs with the Multicultural Judges and Lawyers section. We host an annual supplemental bar review. I'm sure most of the people in here doesn't apply to you, but if you know someone, particularly a minority, that is planning to sit and study for the Delaware bar, we host a course to help with furthering your chances in studying and being prepared for the bar exam. So I believe they're putting our emails in the chat. So please, if you know someone that's planning to take the Delaware bar, reach out to Nicole and I so we can get you hooked up for that class.
Thank you. And we have also Christine Keels in the chat. I work for federal probation and parole in DC, and would also be happy to talk to students and young people about community supervision. So thank you, Christine, for that. And thank you so much, Paige, for those remarks. That's important information as well. I'm sorry. We're going to save the chat and make sure that we post it to make it available and send to all of our participants. Any final thoughts from each of our panelists?
I just want to say thank you. Thank you to One Village Alliance. Thank you to Raising Kings, to our esteemed panelists. Thank you all for having us, for making the time to be here. I really enjoyed the conversation tonight. I hope everyone learned a little something new. But this was really a great forum, so thank you.
Thank you so much to each of you. I want to make sure that you know that we are so grateful to you, Paige Chapman, Esquire, to you, Nicole Mosey, Esquire, to you, Mr. Fernandez, Judge Chapman, Officer Chapman, Kiati, for joining this important conversation tonight. I can't thank Wally Rushton and the Delaware Barristers enough for your continued participation in Raising Kings Week. And I really just want to appreciate all of the educators, parents, and students who are joining us this evening. We tried to get to all of your questions. Please share this event. It was live, you got to participate in it, but this is information that could really help provide vital support and resources and a knowledge base to move from now into the future. Again, this is the 9th annual Raising Kings Week. I want to give thanks to our sponsors, Delaware Humanities, to Flux Consulting for helping us to manage the event this evening, Christiana Healthcare Systems, so many partners who have been a part of making this Raising Kings Week another success. You have not missed it. If you're here, that means you already know where the registration link is. Someone was kind enough to share it with you, but share it, share it, share it. It's iamthevillage.org, and we still have a whole schedule of events. Tomorrow, we're gonna have a Fight for Fatherhood film live right here again, virtually, globally, so you can share it and be a part of it anywhere in the world. And then Saturday, we'll end with our Raising Kings conference. Again, it truly does take a whole village to raise a child. We look forward to seeing you. Again, thanks to each of our panelists and all of our sponsors. I'm Chandra Pitts, President and CEO of One Village Alliance. And from the bottom of my heart and all the families we serve, we thank you. Have a good night.